We will hear argument this morning in Case 25A312, Trump versus Cook. General Sauer.
Mr. Chief Justice, and may it please the Court. Deceit or gross negligence by a financial regulator in financial transactions is cause for removal. In a 2-week period in 2021, Lisa Cook submitted mortgage applications for 2 properties in Michigan and Georgia. In both, she told the lender that within 60 days, she would occupy that property for 1 year as her principal residence. As President Trump stated in removing her, it is inconceivable that she was unaware of the first commitment when making the second, and it is impossible that she intended to honor both. Such behavior impugns Cook's conduct, fitness, ability, or competence to serve as a governor of the Federal Reserve. The American people should not have their interest rates determined by someone who was, at best, grossly negligent in obtaining favorable interest rates for herself. Cook's conception of cause contradicts the term's longstanding meaning and overrides Congress's deliberate decision not to impose the inefficiency, neglect, or malfeasance standard here. Her claim that she has a property interest in her public office was roundly rejected by the founding generation as pernicious in a Republican system of government. Her claim that the statute grants her notice in a hearing contradicts this court's cases requiring very clear and explicit language to restrict the president's removal power. And any such process would be futile because for months she has never personally disputed the substantial truth of the material in question. Finally, the remedy she obtained, a preliminary injunction countermanding the president's decision and reinstating her to office, violates longstanding principles of equity and was conspicuously non-existent in our nation's history from 1789 until 2025. I welcome the court's questions.
General Sauer, this isn't central to the case, but it is an antecedent point. On what basis are we to conclude that the Federal Reserve is an executive branch agency and hence that the president does have a removal authority?
Justice Thomas, excellent question. I would say 2 things about that. The first one is, of course, that the Federal Reserve, there's an academic dispute about whether or not the Federal Reserve's open market operations constitute executive power or something else, essentially private conduct. However, Congress has, over the years, kind of packed on traditional executive powers on the Federal Reserve. So the Federal Reserve can issue regulations about reserve requirements in banks and even credit card fees and so forth. So even if the court were to think that some of what the Federal Reserve does isn't executive at all, certainly there are traditional executive powers at issue here, and therefore we contend that this, even though we haven't disputed the validity of the Article 2 removal restriction here, this case is not transparent to Article 2. And certainly there's a statutory authority that's very plain here because it says removable for cause by the president. So the statute is unambiguous, giving the president removal power, and we contend that at least there's what's kind of been packed onto the Federal Reserve over the years by Congress is clearly quintessential executive power. And we acknowledge what the court said in Wilcox, which is that it's a quasi-private, uniquely structured entity that stands in the distinct historical tradition of the first and second banks of the United States, and therefore we have not challenged the removal restriction in this case.
Counsel, I want to, before we get back to the legal questions, I want to start with a little factual one. You began by talking about deceit. Is what you said after that apply in the case of an inadvertent mistake contradicted by other documents in the record?
We would say yes. For example, the president's removal order says either this is deceit or at least it's gross negligence. And now, obviously, they've released a letter of counsel, not from Cook herself, 2 days before the close of briefing here, where they contended that it was an inadvertent notation. But, of course, it's the sort of inadvertent notation that people could be indicted for, or at least the federal regulators are forced you to buy back your loans. It's a very significant representation that, to the lender, this is going to be my principal residence, because obviously you get a better interest rate if that is, in fact, your principal residence. So it suffices from our perspective, and therefore there's really no material facts in dispute, that the president determined that this is at least gross negligence. Even if it was inadvertent or mistake, it's quite a big mistake, so to speak, in a key financial representation made in the context of interest
Well,
rates.
I mean, I suppose we can debate that, with how significant it is in a stack of papers you have to fill out when you're buying real estate. But I gather under your position it doesn't make a difference, right? In other words, the determination of cause is unreviewable, right? So it doesn't make a difference whether this was an inadvertent mistake or whether it was a devious way to get a better interest rate. Doesn't matter for you, right?
Let me put it this way. We would contend there's judicial review kind of at the outer perimeters of cause, whether something goes to conduct, fitness, ability, or competence at all. But once you're within that, and we clearly are here, then there would be deference to the president. We derive that from at least three sources. First of all, the statutory language, cause without further qualification, is itself, in its plain language, a broad, conferral of authority on the president himself. Secondly, we think that places that within the line of cases going from Martin against Mott through Dalton against Specter and beyond Payne and so forth, where the president has broad discretion, and the court has consistently held in those cases where the president's granted this broad discretion, then that's not judicially reviewable. And there's statements to that effect, obviously, in Marbury itself, that they disregard pages 165 and 166 of Marbury. But even if the court doesn't accept that, there's a further layer here, which is that they've conceded this is an ultra vires challenge, and this court held last term that the standard of review in an ultra vires challenge is very, very high for them and very deferential to the president itself. It kind of, dovetails with our Dalton and Martin argument as well. In an ultra vires challenge, the burden would be on them to show that what the president did is entirely in excess of his delegated powers and contrary to a specific prohibition in the statute. So there's kind of three ways to get to the same conclusion there, which is that once the president's made a determination, it clearly does relate to conduct, fitness, ability, or competence for that office, then at that point there's no work for the reviewing court to do. The traditional discretion to the president's determination would kick in.
Counsel, were any of these questions, except the constitutional question, decided by the D.C. Circuit?
The D.C. Circuit, in its stay opinion, relied exclusively on the sort of
notice and an
property
opportunity to be heard. That's what it said the Constitution required, correct?
It said that, yes. It said there's a property interest in this office under Loudermill.
That's the only issue it addressed. It did not address all of the things you've talked about today. What the definition of cause is, including whether it includes pre-office conduct and how much or what nexus there has to be between pre-office conduct and post-office conduct. One could imagine that what would constitute for cause during office would be different than what would happen pre-office. Even yourself below said if something was known before confirmation, you likely can't rely on it. You haven't quite said that up here. But logically, pre-office has a different temporal connection. Then the court didn't address whether the president's determination of cause is reviewable and under what standard. Ultra-virus seems to me to be whether or not another, and that's what all our cases have ever said about ultra-virus situations, whether another entity, another adjudicatory entity, has jurisdiction or we do. And 3, whether Cook has a right to notice and hearing under the statute and what that means, and what remedy, if any, Cook can seek now or finally in the case. You ask us today in this emergency application to provide to finally decide these issues. I want to know why. Meaning, the president, by your own admission, cannot fire someone for disagreeing with his policy choices. You've conceded that, correct?
Correct.
All right? So it's not as if keeping her is going to thwart any right he has to run the department, because he has none. He's conceded that. On policy, he does not. Now, it's not as if she's been incompetent, negligent, or committed malfeasance while in office. This is something pre-office. So keeping her in office is not causing an immediate harm to the agency. Number 3, we know that the independence of the agency is very important, and that independence is harmed if we decide these issues too quickly and with not due consideration. So waiting, to me, to have at least the lower courts look at these issues first makes the most sense to the public's confidence and to the world's confidence about the due process of law. Explain to me why the president's harm is greater than the public's, greater than the Federal Reserve, who deserves to have people acting that have been in office. And number 3, why we should disrupt, as we said in Wilcott, the disruptive effect of repeated removals and reinstatement of officers. Why shouldn't we wait till the end of this case, where all the issues are clear and where we make a final decision as to whether she should have been removed or not?
Let me start by addressing that last point. We are seeking a stay of an unprecedented preliminary injunction restoring a principal officer of the United States after being removed by the President of the United States.
112 years, and it's unprecedented that any Federal Reserve officer has ever been removed. So the unprecedented nature of this case is a part of what the President did, not what Ms. Cook did.
I think that statement has to be qualified by the recognition that there have been situations where governors have been credibly accused or found to have engaged in financial improprieties, and those governors have resigned. Financial improprieties that are quite analogous to what is at issue in this particular case. But I want to make the fundamental point that in Sawyer, this court held that a preliminary injunction was not available to restore an officer. Sawyer was a preliminary injunction. It's a preliminary injunction against the...
That's true, but weeks later in Drago, we permitted an officer who was still there to stay. So that was a case of reinstating someone. We have plenty of cases that say keeping someone in place who hasn't left yet is different than issuing a preliminary injunction.
I think the court's referring to the Delgado case, and in that particular case, it was a writ of mandamus to an inferior there, the clerk, to recognize the de facto officers when there was dispute about who had been validly elected to be the city commissioner or whatever the statute was. And this court said you could grant a final judgment in mandamus to say you have a ministerial duty to recognize the de facto officer. That is totally different than issuing a preliminary injunction. Keep in mind, there is no such thing as final mandamus. And in fact, Judge Friendly once described that as the starkest of solecisms. Sorry, there is no such thing as a preliminary writ of mandamus. Judge Friendly described that as the starkest of solecisms. What this court held in Sawyer is there is no jurisdiction to issue a preliminary injunction restoring a public officer to office. And that's a holding of the court.
She never left. She's still there.
She has reinstated what the court framed its holding as. There is no jurisdiction over the appointment or removal of inequity of public officers. So it does not turn on whether or not she's sort of, stoutly staying in office or whether or not she's gone and then sued later. Nothing turns
General
out.
Sauer, can I ask you a question that's also related to the stay factors? Justice Sotomayor brought up the public interest here. And we have amicus briefs from economists who tell us that if Governor Cook if we grant you your stay, that it could trigger a recession. How should we think about the public interest in a case like this?
Yeah, two things to say about that. One is, if you look at what actually happened here, she was removed on August 25th, and the stock market went up for the next 3 days. So we've already had a kind of natural experiment, so to speak, about whether or not the predictions of doom will really be implemented. And surely that if investors are jittery or whatever the argument is, you would have seen that on August 25th, and you did not see that. In fact, you have these surprised...
Well, I'll interrupt you there to say that I don't want to be in the business of predicting exactly what the market's going to do.
I agree, and that's why I think the court ought to consider all those amicus briefs and their sort of, predictions of doom with a fairly jaundiced eye. What the court has to do is weigh essentially what you have in those amicus briefs is a reflection of very elite opinion that
But there's
what's
a
happening
risk, General Sauer.
Yes.
I don't want to be responsible for quantifying that risk. I'm a judge, not an economist. But if there is a risk, doesn't that counsel in the stay posture when the equities are at stake caution on our part?
I think the court has to weigh that risk against the risk that there will be a permanent damage to the Federal Reserve's credibility from allowing an officer, a governor, to remain in office who's engaged in this kind of behavior before she gains office.
Do we also engage in some weighing of our own about how serious we think the misbehavior was in the stay posture? And I'm not talking about once the case was here on the merits, but if she were accused of murder or something like that, if we're talking about something that was really an infamous crime, should we take the nature of the crime into account in the stay posture in the weighing of the equities?
I think what the court ought to take into account is the close nexus between the conduct at issue here and the duties of this incredibly powerful position that has sweeping, powerful authority over the entire United States economy. The governor set interest rates for ordinary Americans all across the country. And here, there's the appearance of having played fast and loose, or at least been grossly negligent in getting favorable interest rates for herself.
So it's appropriate
What's the
to
message
take
to
notice.
ordinary Americans that comes out of that is the question for the court. And how do you weigh that against the elite opinion that's reflected in the amicus briefs? Obviously, President Trump's voice speaks to that concern of ordinary Americans. I think with the balance of the equities, what the court ought to do is look at the merits, which are extremely strong for us, and then look at its traditional and can stay factors. The court says when the government is a party, the irreparable harm to the government merges with the public interest. And here we have traditional irreparable harms, injuries to the president's ability to remove a principal officer of the United States. When you look at, for example, the originalist evidence we've talked about in the decisions of 1789, when everybody said, or both camps were saying, of course the president can engage in suspensory removals, and we have a preliminary injunction that is conspicuously non-existent, in your words, in CASA, for 225 years of American history.
Mr. Sauer,
that's how it should be balanced.
General Sauer, excuse me. I guess I think you may have to be a little bit more specific with respect to the irreparable harm that you are alleging. Because really, as Justice Barrett sort of indicated, we are in a stay posture here. So the question is, to what extent do we believe that the president or the public is harmed by allowing Ms. Cook to remain in her position for the pendency of this case? I'm not sure that we have evidence here that Ms. Cook is an immediate threat to the public, that she's been in this position for a long time. The kinds of things that you're pointing to, as Justice Sotomayor indicates, are not related to conduct while in office. So it would seem to me that on the stay factors, you would have to say more about the harm of leaving her there for the next however many months while this case is being litigated.
We have a remedy here, which is a preliminary injunction. This court squarely held in Sawyer there was no jurisdiction to issue.
Yeah, but I'm not talking about the court's power to do it. I'm talking about assuming we have the power for the moment. I appreciate that you say we don't, but assuming that we do, the question is what is the harm of allowing that injunction to remain because she's in office now and would just continue?
Among other reasons, we assert grievous, irreparable injury to the public perception to the Federal Reserve of allowing her to stay in office. They argue that this is going to cause the markets to tank.
And you have
when
evidence related?
They didn't tank.
You have evidence related to the public perception, or is this just the president's view?
The president has made that determination. It's reflected in the language of the dismissal order. And as I discussed in my opening, there's this close
Did the president make that determination based on evidence presented to him in the context of some kind of hearing related to Ms. Cook's conduct?
The Federal Reserve governor who sets interest rates for the entire country appears to have engaged in improper behavior.
No, I understand.
You're repeating.
Counsel,
you're
please
repeating.
allow the justice.
I'm sorry.
You're repeating the allegation. What I'm asking you is the evidence that supports that allegation. Traditionally, when an allegation is made about someone's misconduct or whatnot, there's an opportunity for that person to present evidence, for the other side to present evidence, and even if the president was the final arbiter of this, one would expect that he would do so on the basis of evidence. So what I'm trying to understand is what is the evidence that has been presented and considered with respect to Ms. Cook's alleged misconduct?
Well, the removal order addresses that because it.
What is the removal order? The Truth Social post?
No, it's the August 25th letter. I think it's Doc 1-4 in the district court. But the removal order addresses that. The evidence is you have mortgage applications within 2 weeks of each other that make clearly conflicting representation.
Was Ms. Cook given the opportunity in some sort of formal proceeding to contest that evidence or explain it?
Not a formal proceeding. She was given an opportunity in public because
in
she
the
was
world,
notified.
like she was supposed to post about it, and that was the opportunity to be heard that you're saying was afforded to her in this case?
Yes, and she's had plenty of opportunities in the ensuing months where we've had ongoing litigation where there's never been a personal statement addressing that or justifying it.
General, let's just suppose with me hypothetically for the moment that the court read the act to require notice and a hearing. I assume everybody has notice now. Here we are. What would that hearing look like?
I would point to what the court has said in Vermont Yankee, which this court is very reluctant to dictate procedures to even federal agencies. And here the court would be dictating, or a court would be dictating procedures to the president. I think they rely heavily on Loudermill. Obviously, we dispute that there's any notice and hearing requirement, but Loudermill requires only very minimal, flexible procedures.
Would that be calling Ms. Cook into the Roosevelt room, sitting across a conference table, listening for I don't know how long, how much evidence is a lawyer required, and then making a decision? Could that suffice, you think? What would be required?
It would probably be if the court were to conclude that, it would have to be entirely dependent on the executive to decide. And that's what the case law indicates. Certainly, I think the question points out a great weakness in their argument, which is that the word cause does not include notice in a hearing on its face. Congress knows how to provide notice in a hearing. It did so in the NLRA 1 month before it reenacted the for-cause restriction here in 1935. And because it's not there, the court has nothing to provide guidance on that point. And if the court were to conclude that, it would be up to the executive's discretion.
Just a meeting across a conference table finished with you're fired? I mean,
all Loudermill says is that you have to be told of what the basis is of the allegations against you and give a chance to tell your side of the story. We believe that was provided in the 5-day window between the Truth Social post and the removal letter.
And then you mentioned on remedy that there's no such thing as a preliminary injunction for mandamus, and I just wanted to hear you a little bit more on that. You mentioned Judge Friendly. Please, thoughts.
So the contention in the amicus briefs is that you could rely on Delgado to sort of bypass the holding of Sawyer and say that mandamus can provide essentially the same relief as a preliminary injunction. I guess the argument would be you'd have to mandamus everybody, so all the members of the board to treat her as if she's still a governor, all the staff to treat them as if they were still a governor, because Delgado held where there's the city clerk who can't decide who is validly elected city commissioner. The court held you could mandamus that clerk to recognize the de facto officer in the interim. And that doesn't work for a couple of reasons. First of all, this is a preliminary injunction. Mandamus would have to be a final judgment, and that's what Judge Friendly said. There is no preliminary mandamus. That's the starkest of solecisms.
Do I understand you, General, going back to Justice Gorsuch's first question, to continue to maintain that, in fact, there is no requirement for notice and opportunity for a hearing? Is that right?
Absolutely, yes.
And why is that? Just because it's not stated in the statute?
It's not stated explicitly in the statute, and Congress knows how to provide that because it did so a month earlier in a similar statute and has done so in many, many statutes.
It doesn't do that. Yeah, I thought that with respect to the neglect and efficiency standard, you do recognize notice in a hearing for that, but not in this statute. Why the difference? Because neither is stated.
Yeah, two reasons. In both Shurtleff and Reagan, this court expressly recognized that phrase INM or specified causes would bring with it notice in a hearing. And that's part of the court's holding in Shurtleff, as I read it, because there it was an INM standard,
right.
And there's a removal with no notice or hearing, and the court held, well, clearly this wasn't for INM because it was notice in a hearing.
Your reasoning would be that was a mistaken holding, because since it's not stated in the statute, there's no need for notice in the hearing.
Not exactly, because the old soil argument that we reject as to just simply cause is, we admit, much stronger when it comes to specified causes. So we don't think the court necessarily got it wrong in Reagan when it said specified causes mean that notice and hearing are provided, because the case law, it's the one point in which the sort of background case law does seem to be unanimous. On the other issues where they contended the case law all goes in one direction, you have their own sources saying they're all over the map, they're directly contradictory.
But the
example,
outcome of your position is that in this case, where you don't have the inefficiency neglect standard, the president need not provide any notice, the president need not provide any hearing, the president just really has to say, Ms. Cook, you're fired.
He has to provide a cause. We contend that there has to be a cause, something that relates to conduct, fitness, sufficiency, or competence. We concede it cannot be for policy disagreement or for no reason at all or at will.
General Sauer, if you're correct that courts do not have the authority to reinstate a removed officer, why are we wasting our time wondering if there's cause or not? I mean, because even if we say, yes, there is cause, shouldn't have removed her, but we don't have the authority to order her reinstatement. How is that consistent with the time and energy being spent on determining if there's cause?
We agree that that's an alternative basis. As we say in our brief, that's reason enough to rule in our favor, and we have a holding of the court, Sawyer. We also have this tradition I was referring to earlier of recognition that runs from the decision of 1789 to all the opinions in Myers, it's alluded to in Wiener and so forth, recognizing the president's power of interim or suspensory removals. So we agree that's an alternative, that's an independent basis for us to prevail.
Well, it's an independent basis. I guess it's not independent in the sense that if that's right, the other one is irrelevant, right? It seems to me that if there is any level of cause, and you indicate that there is some level of cause, right, well, then you can't be right about the idea that courts can't order anybody who's been removed to be reinstated.
There is a traditional remedy to reinstate we don't dispute. There's a traditional remedy to reinstate wrongfully removed officers, which is mandamus. But they don't argue mandamus here, and the reason they don't argue mandamus is they face a number of insuperable obstacles to prevailing in mandamus. One is, of course, going all the way back to Marbury against Madison. You can't mandamus the president. His discretionary acts. In addition to that, there is no preliminary writ of mandamus, as Judge Friendly pointed out and the Seventh Circuit has held. In other words, and keep in mind that the standard in mandamus would be clear and indisputable right to relief. And in fact, this is an ultra-virus challenge where the standard is exactly the opposite.
So there's a circumstance in which a court can order the reinstatement of a wrongly removed officer.
But there is a traditional remedy, mandamus. Here, obviously, it'd be quo warranto if there were two competing claimants, but where there's just the one, that would be mandamus. And they have not argued mandamus. They're trying to find their way around mandamus because the standards to prevail under mandamus are insuperable, and they clearly cannot meet them.
But General,
thank you. I'm sorry, Justice Thomas, Justice Alito.
Is there any reason why this whole matter had to be handled by everybody? By the executive branch, by the district court, by the D.C. Circuit in such a hurried manner? You began by laying out what you claim to be the factual basis for the for-cause removal, but no court has ever explored those facts. Are the mortgage applications even in the record in this case?
I know that the text of the social media post that screenshots to the mortgage applications is in the record, but I don't recall if the paperwork itself is in the record, in the district court's record.
So when this was before the executive branch, it was handled in a very cursory manner. The district court decided the case on the ground that for cause doesn't mean anything that happened before the person took office. And I'll question Mr. Clement about that when he stands up. The D.C. Circuit decided it on two grounds, the same as the district court, and that there's a property interest in holding the position of governor of the Federal Reserve Board. Am I right on that?
Not exactly. The D.C. Circuit stay panel relied only on the property interest, did not rely on the pre-office misconduct, and that's insupportable.
Well, did it not hold that that's what for cause means?
My recollection is that the D.C. Circuit, the Garcia opinion in the D.C. Circuit relied solely on Loudermill and the due process property interest, which is baseless for the reasons we say. And that now the district court relied on the twin grounds, both that Loudermill rationale and also the
all right, I stand corrected on that. But those are the only two issues that were decided by the lower courts.
That's correct.
Justice Sotomayor?
I have a couple of follow-ups on Reagan and Shurtleff. You're relying on those two cases for your proposition that cause could be whatever the person, the authority decides. But Reagan and Shurtleff were very careful in holding that the only reason that was true was because there would be life tenure involved otherwise. It was very careful to distinguish its holding from cases in which there were a tenured position and there was a for-cause provision. So you're extrapolating, correct?
I disagree with that. We read Reagan differently. If you have those two key
No, we
paragraphs,
can
in
both
Reagan,